Gautam Shahi. I'm a partner with Dua Associates, and my area of practice includes competition law. Today, I'm here to discuss the competition amendment bill, which has been passed by Lok Sabha. While there's been a lot of changes introduced as a result of this amendment bill, I want to discuss the 5 major changes, the way I see them. While most of the other changes that we see are a result of the learnings of the Commission over the last 15 years of functioning, about 15 years of the functioning, the 5 major changes that I see are: 1, the introduction of deal value threshold. And by the amendment bill, there is an introduction of a new threshold. So any transaction which has a deal value of 2,000 crores or above 2,000 crores, and where the parties have substantial presence in India, will be required to approach the Commission and take its approval. So there is a wider net now. Next is the reduction in combination assessment timelines. There has been substantial reduction in the timelines for approval of mergers and acquisitions, which require CCI's approval. Initially, CCI had 210 days to approve a combination. Now they have 150 days as per the new amendment bill. CCI was required to give a prima facie view within 30 working days. Now they'll be required to give a prima facie view on these combinations within 30 calendar days. So that's a significant reduction. A big question there is whether the CCI will have the requisite resources, the manpower resources, and the expertise that is required for assessing combination within these new timelines. Next is anti-competitive agreement provision has been expanded. As on date, an anti-competitive horizontal agreement under Section 3(3) of the Competition Act can only be between competitors. However, the bill seeks to introduce a new proviso by which any entity which actively participates or assists in the formation of a cartel or execution of a cartel or a horizontal anti-competitive agreement can be penalized by the Competition Commission of India. Next is the issue of settlement and commitment. And these, I believe, are the most important changes, whereby entities which are under investigation can enter into a settlement or a commitment agreement with the Commission and resolve an inquiry or an investigation. This will ensure that the Commission does not need to employ significant amount of resources and time in investigating an anti-competitive conduct. This will also ensure that entities who may have mistakenly violated competition law but are willing to cooperate with the Commission are able to do so and reduce their legal expenses. Lastly, there is a significant increase in the penalty amount that CCI can impose now. As on date, the law provides that CCI can impose a penalty of up to 10% of the average turnover for the last 3 years for an anti-competitive conduct. With the new amendment, CCI will, when looking at the figure of the turnover, will be looking at the global turnover of the entity and global turnover from various different products, different product lines that it has. This has been included specifically to address the changes made in the interpretation of the penalty provisions by the Supreme Court, Honorable Supreme Court, in the Excel crop care case. Let's see whether this amendment bill is passed by Rajya Sabha as well. Thank you.